Okay, well, welcome everyone to the Public Law Exam Workshop for this semester. I'm Tian, and I'll do my best to give you a high-level glance at what the course entails. You should have a good idea by now, but I'll try to just outline the key factors. Just before we move forward, just keep in mind that I did do this course in 2013. So I don't know about things you did in the last year of high school, but I can't remember that much of it. Although I did do a little bit of research before this, so I'll try to convey to you what I still recall. Just keep in mind that the course might have changed, and even then your lecturers would know more than I do. So if anything conflicts between what I say and what your lecturers told you, definitely stick with what your lecturer said. They'll be marking your exam, so what they say definitely takes priority. Just on this note as well, we've only got an hour here today, so I'm really going to try and cover as many of the points as possible, and a sort of byproduct of that is that I'm not going to be able to go into that much detail. So if you're having trouble with, for example, just one specific part of the Bill of Rights aspect, and you need an in-depth understanding, today might not be your place to get that. I'd suggest reading the cases if you're really having trouble. But my plan today is really just to, again, give you an overview of what each of the topics would involve and how you might go about framing all of the different concepts involved. And that's just a brief structure of what I followed today. But since this is for most of you at least, your first proper law exam, I'm going to go over just a few tips and ways in which I approach my exams. And then I will go over some of the content, and then I'll go over an answer I did to a judiciary question back when I sat the exam. Okay, I've been told these are your exam instructions. I'm sure all of you have them. Similar than other years, it's an open book exam. You probably haven't sat open book exams, most of you. I rely on my notes quite a bit, but that being said, the bit I would rely on it's like one page for each topic. So do not be dependent on like a massive textbook or 30 pages of notes on one topic, because you just don't have time to look through all of that in the exam. It's really key, in my experience, to make good summaries and be able to identify, say, a one-sentence principle of law, and copying that into your exam doesn't really take much time. You would have noticed it's a bit different from other years' exams in that there's apparently the Parliament topic won't be examined in its own right. Now, you may read into that all of the other topics will be independent questions. I would have been tempted towards that conclusion, although they probably would have told you that there will be some overlap. Is that right? Yes? So they did say that when I did it, because all of the years before that they were pure independent, they said that for me that there will be overlap. We didn't really have much overlap, but definitely be on the lookout for overlap between questions. You might get that more now that the Parliament isn't examined in its own right. Now, these are just sort of mostly common sense things, and that the key thing that you need to do is you actually need to put in the hard work and study if you do want to do well in a law exam. Of course, you can come to a workshop like this, and I certainly went to these workshops and found them very helpful and giving you guidance moving forward. But the most important thing is definitely to do the hard work. Your exam's probably 2 weeks away at least, and there's definitely enough time to still do well, even if you haven't done much all of the year. What I find really good is to actually, because some of you might find it hard, how do you actually study for law? And how I study is I make my notes, and when I say that, I don't mean you have to write your own notes from scratch. I copy and paste all sorts of things from all sorts of places, and it's really just the act of, for me, compiling all of this information into a format which you designed, and then becoming familiar with that format through answering old exam questions is really the primary way I would study for these exams. Now, how I do my notes is what I take into the exam is I have two sets of notes. And the one is what I call my sort of full or extensive notes. And this is really everything that you have learned or you have covered in class. Ideally, you do not want to be relying on this. I think I've looked at my full notes in one exam so far, and that was only to find the name of a specific case that I was thinking of. So your full notes are really just there to bail you out if you've got that in the back of your mind and you can't quite think of it. And on the other hand, you've got your, what I call my summary notes. Now, some people make template answers. I don't make template answers in a traditional template style that you start with step 1 and you follow through to step 10. But what I like to do is identify the key concepts. Because if you can identify the key concepts and then maybe one sentence summarising the case and what it stands for, then that key concept will translate into the issue that you're given in the exam. And then if you can spot all of the issues in the exam, it should be quite simple to then move your concept notes, which is essentially each issue, to your exam, and then you just apply it. The reason I follow this approach, it affords you with some flexibility in the sense that you've done X amount of work in the course, you will be examined on that work. You don't know which of it you will be examined on though, but if you're able to spot the concepts and you have notes on those concepts, you should be able to answer any question. Where if you're following a template for the Parliament topic and they're mixing it up a little bit, then you might get thrown just because it's not exactly as you prepared for. Does that make sense? Yes? Okay. And just a note on the textbook. I personally found the textbook quite dense and with a lot of information that won't necessarily be key to your exam. So I didn't pay too much attention to it. But if you don't understand the topic, it's certainly a very good resource to try and gain deeper understanding. Now, what I said before, so what I'll do, if I'd study, I'll do all my notes, get all that done, and then you should ideally have a day or two to just work through past exam questions and go through the process, time yourself, and just become familiar with all of your notes. Some people like study groups. Personally, I haven't found them to be that constructive, but it depends on the people you are with, I guess. And just another thing is, it might seem big, these law exams, but just try and put it in context. It's still only one exam, and especially public law is a really good one to really put a lot of work into, because if you do end up doing well, is it still 100% passage? Yeah. Yes. So my coursework was on something like 70-something%, and my exam was higher than that, and it bumped me up completely. So this is really a good opportunity to put in a lot of effort, and everything you do throughout the year, and you might not be happy with that, or you think you can do better, and that can all just go away, and this is your chance to still do really well. Where with some of the other subjects, you might have a bad course mark that will drag you down. Now, during the exam, and this might seem again like common sense, but the most important thing is to really read the question. You might be tempted to just try and go through it as quickly as possible and then start writing all these things you've learned. But definitely try to just stay calm and take the question line for line and make sure that you understand what exactly you're being asked. It's definitely worth it to spend even 5 minutes or so per question into the actual exam and just look over the question again if you're not sure what they're asking, because it's definitely going to be more beneficial to ensure that you have that understanding before you start writing. Maybe you have a little bit less time to write, but it's a lot better than starting to write and having no idea what you're doing. As I said before, you need to be able to spot the different questions and link them to topics. I don't know if some of you have looked at past exams, but in 2013 we had a question, and it was the Parliament question, but it started off with reference to the Atkinson case, which you would have done the Bill of Rights topic. So what happened to some people is where they had prepared templates, they immediately saw Atkinson Bill of Rights and they started doing that. But it wasn't a Bill of Rights question at all. It was essentially the person asking whether Parliament can do something, which the answer is mostly yes, they can. So just on that note, be clear to read the question well and make sure you know what you're being asked, and that you're able to link different concepts together when that is required. And just that sort of goes over again what I said. Make sure you know what the person wants. They often give you a context in the sense that you're advising a judge or you're advising an individual. Try and conceptualise at the start of your answer what this person wants and what their remedy might be. For example, you're advising Bill if Parliament can take his right to compensation away, because if they can't, then he might be entitled to some compensation. Stating something like that at the start of your answer just gives the marker context, working all the way through, like, why are you doing this analysis? It shows them where you're trying to get at. And with this being an open book exam, try and be selective in what you write down. Everyone's got a lot of notes and everyone's got the content, but it's where you get the most marks is where you apply things. And you probably would have been told this in the past, and it's hard to know exactly what it means to apply things. But the way I understand it and the way I try and apply it is that if you say have a line or two on what the law might be, and if you then start talking about the facts from the question and the law that you've prepared, and if you're mixing that together in the same paragraph and the same answer, then you're going to be applying the law. It's practically impossible to be talking about the problem facts and the law together, intermingling them without applying it. So if you're a bit unclear on what application is, that's my model that I try and follow. When you're reading cases, some people might have told you that through first year you can go through without reading cases. I can certainly say that up until my point, you can manage to do quite well without reading any cases. They're not that important, and the reason they're not that important is that today you've got so many resources. You've got other people's notes, you've got these textbooks, you've got these little Butterworth's companion books are quite good to work with as well. And in the context of a 3-hour exam, what you really need to understand are the key principles coming out of the case, so the propositions of law. And you want to have a fairly decent grip on the reasoning in those cases as well, in the event that you do need to go into more depth. But the facts aren't important. I would say in most of my exams I don't talk about the facts of cases at all. It's just not that important. I'm not saying discard the cases. All I'm saying is if you're short on time and you can't read them, it's not a big deal. What I use cases for now is I don't look at the course book, but the database is online where you get the cases. And then if you've got a keyword, to just do a Control F search and focus on specific paragraphs, that can actually go a long way towards helping you understand the case. And if you've got the official reported version, so something like the NZLR citations, in the head notes you'll get your held and your propositions of law. But if you just go a little bit further, they'll normally give you a paragraph citation behind that proposition. So I would say it's definitely worthwhile looking at those specific paragraphs if you do want some further aid to your understanding. When you refer to the actual cases, you don't have to write up your full citations, as long as you can. They know which case you're talking about. For example, if you think you meant to underline all cases, so definitely do that. But if you identify one of the parties and there's no cases with the same party names, then the case, they should know what case you're talking about. That's fine. So for example, just Atkinson line underneath it. And I normally write down, especially in part 2, you could say 2005 Supreme Court, just to give an indication of what's the authority you're working with and whether it's binding or persuasive here, because especially in some of these topics you deal with a lot of English cases and you want to be clear on what their precedence value is. And just a couple more things before we get into the content. These exams are very time pressured. They're designed to be such. And my strategy is really to, the percentage of marks that a question is worth, you want to allocate the same percentage of time to that question. So if you have a 25 mark out of 100 question, that's just a quarter of your time. Put it on that question. And definitely stick to your set time limits per question, because if you are going over time, you might write a better answer here, but it's going to cost you a lot more marks in the second question where you are now neglecting your proper answer. On that note, the examiner is not that hung up on structure normally, so if you're short on time, bullet points are fine. Just make sure you finish. You're going to get a lot more marks for actually showing your thought process and getting towards the end, even if you leave out things, than doing 3/4 of an answer but stopping right there. And I find headings to be very useful in exams. It makes it very clear where you are at and where you are going, and if an examiner looks at your table, your paper, it really just sort of screams out at them, these are the 4 things you've covered on this page, or the 2 things, and so on. I tend to highlight my headings just because my handwriting's not very legible, but it's up to you whether you do that or not. Now, we've gone through a bit of stuff. Now, this isn't related to public law, but I just think it's a funny story, because this case is well, almost 200 years ago now, but that's quite recent, and what it did actually is it upheld the right to trial by combat. And so what happened is this man got charged with rape or something like that, and he appealed, and they said you have the right to trial by combat, and he challenged the other person to combat, and they didn't want to fight, and he got off. So I always find it amusing how it's a relatively modern case. Some of the cases you would have done, especially in the Parliament topic, might be older than that, and that's still valid law. But then we have something like this, so it just shows how the law evolves. After the exam, still, it's just one exam. If you had a bad exam, everyone has bad exams. Just try and move forward, study for the next one, or relax if you're all done. So I think this is pretty basic. You would all know it, but there's normally one compulsory question: judicial review or admin law. It's quite a set structure you follow in those questions normally. And then there will be 4 questions of which you have to answer 3. My guess would be that the questions would still focus centrally on those 4 topics, but I wouldn't be surprised to have Parliament jumping in with some of them. And again, if you've identified the key concepts, then that should be no problem. I also, the only overlap that I did mention is a little bit of treaty in the admin law question when you come to relevant considerations, in that the treaty may be a relevant consideration. Beyond that, I don't really know much of the treaty topic, so just a note here, the workshop today won't really be going over the treaty topic, just because back when I did it, you still had the advantage of being able to discard pretty much a third of the course in your study. But yeah, this might seem a bit confusing, but as long as you identify the concepts and you are comfortable with them, that should be fine. Now, I said I don't think this will be examined in its own right, but I'm just going to try and go over it quite quickly, just because it is a very important part of the course. It's probably the most important that you do need to make sure you understand. Now, the 2 most important topics that you deal with are sort of retrospective legislation and entrenchment. The questions overlap between these 2 topics quite often, so it's not that you've got a template for either one of them. And then there's some minor topics which come up in the course and you might want to keep in mind, but I don't think they'll be in the exam. And the key thing from Parliament, the Parliament topic, is that you need to keep in mind Parliament is supreme. Now, if you can visualise a spectrum where on the one end you have your Picken type reasoning and your Fitzgerald and Muldoon, where Parliament is absolutely supreme, they can do whatever they want. And then on the other end of the spectrum, with relevance to our legal system, you might have some obiter comments from Lord Cook relating to fundamental rights. We're still very much on the Picken side of the spectrum, although we have allowed some, not limitations, but sort of not portraying parliamentary supremacy in its extreme still. That being said, the general theme is still Parliament can do whatever they want. If they don't follow proper process, it's still vague as to how you challenge them, who can tell them what they did isn't valid, and in that event the majority party can still just make a law saying what they did is valid. So in a practical sense, Parliament can just do whatever they would like. And that's just a citation on there for like why Parliament is supreme from the Supreme Court Act. So these are just some key concepts. If you have a law it might be hard to link this back to how this does have to do with parliamentary supremacy, and a nice and easy one, and this relates to retrospective and implied repeal type legislation, is that you may have something that strives to take away fundamental right. Now, our Bill of Rights Act is only an act. Parliament can impliedly repeal any part of it just as they would any other act. So keep that in mind. Again, I don't think this will be relevant to the exam that much, but just try and keep that in mind. And then here we've got some case developments which moves us more towards the Lord Cook end of the spectrum, and we've got something like the principle of legality, which essentially stated that Parliament can legislate against key rights, but they have to be quite clear when they do it. So essentially Parliament has to come out and say, hey, I'm taking away your right to go to court. And the reason for this is that Parliament would then have to confront the political cost. And that essentially means it just brings it to everyone's attention that it is clear exactly what they are doing. A note on Lord Cook and his obiter statements. There's quite a few cases, probably 4 or 5, where he has made these statements. That they have not gained much traction. I would not recommend citing them as any type of authority, other than citing them to say that we are not following that position. But definitely do not make an argument of where we say Parliament cannot take away fundamental rights, because it is established beyond doubt that they can in New Zealand. Then there's just some other things, but you can look over that in the slides. So we've got that, and I've got all of this, so I'm not going to go over this, you can look at it in the slide. But entrenchment is essentially when you try and create a higher law and you try and put special protection on a certain law. For example, you need 67% majority to change a certain act. And the key way that this has been justified is that they say it imposes a manner and form requirement, but it does not limit parliamentary supremacy. Now, your Dicey and other traditional theorists would say that it does limit parliamentary supremacy, because they define Parliament as a bare majority, so 51% of the members of Parliament. And on that note, and this is a really key concept for you to understand, is that when you say Parliament is supreme, that means 51% of Parliament is supreme. Now, with a manner and form requirement, what they are saying is that Parliament is still supreme. Parliament is just being redefined to now constitute 70% of the members of Parliament, or whatever percentage. Is that clear to people? Nodding heads, shaking heads? No interaction? Okay. But yeah, you can look over the slides there. Again, you can look over that in your own time, because I don't think it will be examined. Now, my favourite question was always the judiciary question, in the sense that if you look at the past exams, and to be fair, I haven't looked at last year's exam, but all the ones before that, is you'd have something where a judge essentially did something wrong, or where someone is accusing the judge of doing something wrong. And all of the topics that you did within the judiciary topic would tie in with that. And there's normally a sort of, all the concepts you can follow as different types of remedies which you might try and get against a judge. And the first is that it's fairly well established that judges are immune from civil action, at least so far as that they believed they had capacity to act as a judge. So to put this in a practical context, is that the first part of your question may be, hey, Judge Erickson did something wrong, what can we do against them? Your client, then you, even if you know you can't sue them, you still want to outline for your client, we may want to consider taking civil action against a judge, but that's really limited. Essentially, there's only a possibility of a bad faith exception, which was left open in the Gaisley case. So essentially, civil action against a judge is not an idea you want to follow unless they weren't, or they did not believe they have jurisdiction. For example, if the judge is doing something on the street in a non-judicial capacity. And that section from the District Courts Act, from memory, just extends the immunity to district court judges as well, because in the old law we used to have different types of immunity for different types of judges. Now, the next option that you might then consider as a remedy against a judge is to sue the Crown for vicarious liability. Now, vicarious liability is when liability is imposed on one person for the act of another. And for those of you who have done torts, you would have come across it in the employee-employer context, where the employer can be held liable for acts of the employee while they are working. And the logic here is that the judge is acting for the Crown, notwithstanding separation of powers. But the logic here is that you then should be able to hold the Crown liable, because ultimately they are in some way meant to be responsible for the judges. That approach has been explicitly outlined by the Crown Proceedings Act. And again, these things are pretty clear-cut. No, you can't do that answers, but you still want to consider the option in your exam. Now, the next step that you might want to consider is public law damages. Now, it's Bajan-style damages, and these are essentially damages against the executive branch. Normally, it was in the Bajan case at least, against the executive branch for breaches of the Bill of Rights Act. So, for example, if the police are searching your house and they didn't follow the correct procedure and they didn't have authority, then you may have an action against them for some monetary reward. That being said, it has been limited quite a bit, even in the executive context, and the Supreme Court recently completely ruled out for judicial breaches of the Bill of Rights. That being said, again, it was a 3-2 split in the Supreme Court. The judges have changed since then, so if it went to the Supreme Court again, you don't know which side it will go. So keeping that in mind, you want to expand a little bit when you talk about this as to the approach of the majority and the approach of the minority. Now, I have a bit more on this in a next slide, but the essential concerns of the minority is that the judiciary must still be held accountable, and they view that the majority has gone too far by elevating the judges almost above any type of perceivable liability. But I have a table, or not table, but a couple of slides following this which goes into that in a bit more detail. Another option, and you might want to mention, this probably won't get more than 1 or 2 marks, is ex gratia payments. Now, this essentially means out of grace. So it's a payment that your client may be entitled to just because the government or the Crown recognise they're in a pretty bad position, and out of their grace they're going to give them some money. Now, this is always a good remedy that might be an option where the client has been wronged, but the Crown is denying any sort of liability, or because of judicial civil immunity you can't get any remedy, so the Crown might throw you a few dollars. Again, it's only a line or so in your answer. Now, the key part of the judiciary question, and this is why I like this question, is the JCPA, or the Judicial Conduct Commissioner and Judicial Conduct Panel Act. And this is essentially a body that sets out the process of, if you have a problem with a judge, this is the process that Parliament has said you need to follow. And it's quite a rigid process. In that sense, you get a lot of easy marks by just saying, this is step 1, this is step 2, this is step 3. And I'll get into that in a slide or two. But that process is essentially just how it is laid out in the Act. So you literally write down, our first step is under section X, we need to make a complaint to this person. The second step is then that this person will consider the complaint. If the complaint is so bad, this will happen, and so on. I can't remember the exact steps, but you definitely lay out the steps. And then what you want to do is you definitely want to make a call as to what you think might happen. The sort of extreme remedy is to convene the panel and to have a sort of hearing for this judge. But I always felt it was a good option to just say a referral to the head of bench, maybe a safe option unless it's something really bad. And essentially what that means is it gets referred to the judge that's in charge that judge has to talk to the judge that's being complained about, talks them through what they did wrong, tell them not to do it again, and so on. But it's really a nice and safe option to go with. That being said, again, if it is something that's really bad, the panel may need to be convened. The panel was convened in the Saxmere saga with Bill Wilson, but even then, he was successful in judicially reviewing the panel, and there were problems with the process that was followed. And the key thing for you to take out of this is that we really don't like removing our judges. If you come to the conclusion that a judge will be removed, I would seriously recommend reconsidering that process. To my knowledge, I don't think we have removed judges. What tends to happen if there's a massive controversy, the judge will resign, but it's a really bad look for us to be removing our judges. If a judge is to be removed, there's again a long process that needs to be followed, and the way they get removed is essentially by an act of Parliament. But again, don't say the judge will be removed. We don't really do that. Now, this is the Chapman case, which is when I did the public law. When I came to the public law workshop, I'd not heard of the Chapman case before, so it definitely helped me a lot. So I tried to cover a lot here, and this essentially just goes over the majority reasoning. And they cite things like judges needs to be seen as free from external influences, and litigation needs to be final. And that's a pretty easy to understand concept, so we don't want litigation going on for years and years to follow. Now, a key thing here is that, and Lord Denning said in some case, that we don't want our judges writing with a trembling hand or trembling pen or something. And that's always a good thing to talk about as well, is that it's seen as really bad for our judges to be potentially exposed to liability, in the sense that it might affect their decision making, it might encourage some sort of defensive practice. Really, we want our judges to be seen as completely independent and completely free to arrive at the right result, however unpopular or popular it might be. And here's just some thoughts on what the minority would have done in the Chapman case. And I think at this stage, as it was a 3-2 split, if you have a particular appeal to this minority, it's fine to say that you think there's a lot of strength in this approach, and you think that might be followed by a future Supreme Court. But still, just be very clear that the majority approach is current Supreme Court law, and it is binding. So it will be very hard to get that overturned. There's generally, you don't have a lot of luck trying to appeal issues on which the Supreme Court has directly spoken 4 or so years ago. So the majority approach, as far as I'm concerned here, is pretty set in our law for now, unless it sneaks its way back up. So. Now, this is just, and again, the judicial impartiality tends to sneak into the questions as a byproduct. And this sometimes happens. This is the thing that you are complaining about. And I don't think it really matters where you address this. As long as you can identify the concept and you address it somewhere in your answer, you should be fine. For example, if you explain at the start, the judge might have been had apparent bias here, and therefore this is the test, and we're going to follow this process. Or if you do it within the process, you can really work it in wherever you want. But definitely do not forget about the substance of the complaint that you would be making against the judge. Now, the Bill of Rights, the Bill of Rights topic, the way I understood it at least, is that it's really all about the Hansen case. In that the Hansen case sets out your key process that you would follow in interpreting the Bill of Rights, especially the key sections 4, 5, 6. And it provides a framework to apply these operative provisions. And it can get quite complicated, especially if you're starting to deal with cases such as protest or discrimination, or in the event that it's a bylaw It can get quite a complex process that I won't go into too much detail in. But if you're having trouble, definitely try reading the Hansen case. There should be a bit about it in the latest textbook as well. But definitely this is the one topic where you might want to consider doing a bit of further reading if you can't quite get your head around it. And that being said, the Hansen process is quite clear-cut 6 steps that the majority, or rather everyone except the liars, I'm not sure the majority, set out. So the first step is ascertaining the intended meaning of Parliament. And here you want to be brief. It's the Interpretation Act, Section 5.1, text purpose from 131. Just find out what the meaning is. What you want to talk about is whether the meaning is inconsistent with the New Zealand Bill of Rights Act or any freedom contained in it. This is where I tend to bring in a lot of my, say, discrimination cases or protest cases, where they actually define the extent to which these summary offences laws or discrimination laws apply. And it can then be that you try and determine whether or not they breach the Bill of Rights. It's definitely worth noting the minority approach. I'm not going to go into that in too much or any detail, but look into what Chief Justice Elias said, and just note that at this step, moving forward. Then you want to talk about whether or not the limit is justified under Section 5. Now, you can apply here what's called the Oakes test, and that's from a Canadian case, and it sets out four sort of headings that you need to consider, and then factors within them. And these are things as in whether there's a pressing and substantive objective for the limitation on the right, whether there's a rational connection between the limitation and objective, whether the right has been minimally impaired, whether there's proportionality between the limitation and objective. But again, this is something you would need to go look up, the Oakes test, so definitely make sure you have a good grasp on the Oakes test. I guess it's fairly well publicised on the internet and in journal articles and so on. So definitely make sure you understand all of that. That being said, I think the Moonen case as well covered a bit of Section 5. The position on the Moonen case is a bit unclear. The majority in Hansen said it can still apply sometimes when you have an ambiguous or sort of continuum meaning, but then they also said it's not mandatory. My instinct is to stick with Hansen, but you can definitely look into that if you want to add a little bit to your answer. And then we've got Section 6 and Section 4, which are fairly easy sections. The key thing to remember is that your other meaning under Section 6 needs to be a reasonable meaning. You can't impose a meaning that's completely ridiculous. And in New Zealand, the courts have indicated that we aren't open, because what they're doing in England is they're attaching quite ridiculous meanings to things to make it interpret it consistently with fundamental rights, but we're not really doing that. So definitely make sure you are clear on that. I'm not going to go over these. These are just if you want to tick boxes to make sure you know what was done in class and you've got the key aspects, make sure you've got all of this stuff down. This is just a funny picture. This guy on Instagram posted a picture of him and his guns, and he says, "My rights are not negotiable, and I'm totally unwilling to compromise when it comes to the Second Amendment." Hashtag Bilzerian16. This is what Section 5 is aimed at preventing. We do impose reasonable limitations on our rights. We don't have a right to firearms in New Zealand, but take an example, even if we did, a reasonable limitation may be that we want you to sit a brief licence exam and maybe not have an AK-47. Other than that, it might be something like freedom of speech, where we still recognise defamation law. So these are the classic examples of your reasonable limitations. Now, from here forward, I'm going to go through it pretty quickly so we can get through the answer. But the judicial review topic is really a set process that you need to follow, and there are 3 grounds on which something can be invalidated when reviewed. The first of which is procedural impropriety, and this essentially means you have a right to natural justice. So where you have something like you're being charged with some sort of offence and the other side isn't showing you the case against you, or they're not giving you access to the evidence, those are pretty clear breaches of natural justice. When it means you need to have access to the other side's evidence or arguments or whatever, it generally includes the right to be able to respond to that material and make your own case and correct anything. The rule against bias you should be all very well familiar with. In Drew and Attorney General, they gave a set amount of factors that you can consider in determining whether or not someone, what level of legal representation they may have. For example, if it's like a parole hearing, we're not going to afford it the same process as a Supreme Court hearing, just as an extreme example. So these are things you can consider in determining exactly the elements of natural justice. I've just got a note here on bias that I'm not going to go over, but it'll be in the slides, and that essentially just sets out the Sachs-Meyer process. Now, the next ground for potential review is illegality, and that is when they've acted outside the scope of their power. Here we have things they've acted for an improper purpose. That case, Padfield, talking about the policy and the objects of the Act, and you could always look whether or not it's consistent with the policy that has been set out in the Act. I find in the improper purpose and the consideration aspect, it should be fairly common sense. If the minister is doing something, or the regulator's imposing a regulation because they want to prevent someone's bar from competing with another person's bar, that's probably not allowed. So just use some common sense. Do you think they should be able to take this into account? Or is this what the law was intended for them to be able to do? And then just there's some cases on mandatory relevant considerations as well, and I've noted them there for you now, but you'll have to go into them in a bit more detail in your own time. The other ground, and this isn't, you're probably not going to be successful in this ground. What you want to do is you want to cover all the grounds. Most of them are relevant almost all of the time, and you want to make a call on either one of them. We might be successful here, we might not. And that is what we call Wetnessbury unreasonableness. And this essentially means that it has to be so unreasonable that no reasonable decision maker could come to this conclusion. That might not be of much help, but essentially what it means, it's a really, really high standard. It's going to take something really extreme to meet the Wetnessbury standard. It essentially means something that you can't contemplate any reasonable person in that position would even think of. So if you have something really extreme, so even if it's things like bad faith, or if it's hate crimes or sexist, racist behaviour, it might be something like that. And then you might also want to look into the Wolf case, which talks about discrimination, and I've just got some remedies noted down there for judicial review. These are some other remedies. In the judicial review context, you often deal with the executive branch, and these are just things to note, and the slides explain it, but you can get the Ombudsman. It's a free, independent organisation that makes sure that the government isn't overstepping what they are allowed to do. And then also the Official Information Act, where you can make requests as to certain information, just worth mentioning here and there. On the executive topic, and these next two topics I didn't answer or study that much for my exam, so my understanding is not that deep as of now, but essentially the executive problem can be broken up into two key topics, and then we have the sources of executive power, where we have things like the royal prerogative or the third source, and then in the other sense we have the Governor-General type situations. Now, the royal prerogative is essentially what remains of the monarch's ancient powers, things like to appoint a prime minister, to defend the country, to enter into international agreements, and so on. And that explains that case. You can look over that in the slides. That explains all of that. Then we've got the third source. Now, these are essentially things that the government should be able to do just because they are ordinary people. And rather because ordinary people are entitled to do these things. And this is conflicts with the notion that government needs positive authority to do something. And by positive authority, I mean law that entitles them explicitly to take certain actions. And definitely I think Elias's approach here would be that there is no third source power. If you had Bruce Harris, you might have heard a bit more about her approach in detail and what he thinks of it. But definitely look into these cases and note the majority approach, the minority approach, whether we have third source powers in the government, whether we don't. I think, again, it's fairly well stated that there is a third source power in the government, but, again, note the minority approach. Then we have the Governor-General type question. Now, I never liked the Governor-General type question because it is quite a vague and opening question, and I feel that the content for it is not particularly complicated. It's quite easy. Everyone's going to be writing down the same thing, so I feel if you want to differentiate yourself, you probably don't want to be answering a Governor-General type question. But again, they've taken away the Parliament question, so you'll probably end up choosing between Governor-General and a treaty question. And as there are no previous problem questions for the treaty, at least I think there's not many, it might be a bit of a wild card what you get in the treaty question. So I definitely study for all of the questions given the limited scope that you do have. But what happens in the Governor-General question is that normally there's some sort of crisis. Something has happened and we want to know whether we're following the right process, what is the process to follow, have we done the right thing or have we done the wrong thing? And I've got some limits noted down there, which you can look over in the slides. But essentially what you want to talk about here is all of the situations that you would have covered in class, and I can't remember for any of them off the top of my head, but you would have covered these situations of what happened in other countries, and you would have seen the process that they followed, and you would have, most importantly, identified certain things about the process that were done correctly and things that were done incorrectly. Now, what you want to do is look at the problem question in front of you, try and relate that to some of the situations that you covered in class. If there's an opportunity for us to do something right that was done right in one of the other cases, you want to relate that. If there's some of the things that we're doing wrong that's already been ruled to be wrong in the other cases, you want to do that. And this is probably the one question where it would be okay to talk a little bit about the facts, what happened in some of the other cases. The treaty question is apparently a problem question this year. I think the note said all questions are problem questions. In the past, it's always been a treaty essay question, which essentially said the treaty exists, discuss it in some context. They were really wide, you'd be able to look. So on that note, I don't really know what will come up. I have noted down some key things just from my memory that I felt were covered in the course. But as it is a problem-based question now, I would say there'd be an increased emphasis probably on the cases and the case law. And you want to look at whether you can make summaries and concept notes of those cases to the similar extent that you would do in the other topics. Essentially, you want to apply the same approach here that you would in your other topics. Other than that, I can't really help you on the treaty topic. I've got a past exam question here. I'll just leave that up for a minute so you can read it. Okay, so essentially what we've got here is we've got a judge who may have some sort of interest with someone else, and then we've got a case being argued in front of the judge, and then what's happening is the judge turns out to be somehow indebted to one of the people, but essentially, as I said before, the gist of it is that the people are accusing the judge of having done something wrong here. And again, what we want to do is we want to consider what the judge did wrong. Now here, you might say why judicial impartiality is important. This was one of my higher scoring questions, so I've pretty much copied out my whole answer in the following slides. You want to consider what the judge did wrong. We talk about impartiality is key to the administration of justice. It's fairly self-explanatory why. We've got the different standards of bias that's been covered there. Now, you remember how I said before you might cover the substance of the complaint before the actual process. Now, that's what I did here. I covered the bias and then the causes of action. Now, this is essentially the same as what I said before. We consider all of our options and then we make a call as to whether or not we do have any option available there. Now, we can't sue in tort, we know that, and we can't get vicarious liability. We then have the Judicial Breach of the Bill of Rights Act, which is the Chapman case we talked about, and that just sort of explains a little thumbnail summary of how it's relevant to the answer. Now, here we've got the Judicial Conduct Commissioner, and this is a summarised example of how you would set it out. So your first step is that any person can complain, so your client or the person you're advising will be able to complain. You tell her how to complain, tell her what's going to happen next. Your complaint's going to be acknowledged, some preliminary investigation will have to be done, and then there's a range of options. Now the options are no action can be taken, the complaint can be dismissed, it can be referred to the head of bench, and the panel can be convened. These are in increasing order of severity. Again, referred to the head of bench is a fairly safe option to go with. If it's very serious, the panel may be convened. For example, in the Saxmere case, the panel was convened, but you can note that the whole Saxmere saga and Wilson case has showed us that it needs to be very, very serious for a removal to happen. Are you all familiar with the whole Saxmere saga? Nodding heads? Yes? No? Okay. Essentially what happened is that the judge was in a business partnership with one of the lawyers, and it wasn't disclosed all that well, and they went through the whole Saxmere case number 1, and they said he was fine, and they said if the judge was indebted to the lawyer, it might have been different. After Saxmere number 1, it came out that the judge actually was indebted to the lawyer, which went all the way back to Saxmere number 2. If you are interested, if you Google Ted Thomas, Saxmere, Bill Wilson, something like that, Ted Thomas is actually the one that made the complaint, Sir Ted Thomas. And if you look on these emails that were leaked online between Ted Thomas and Jim Farmer, who's a very prominent QC, and this was before the complaint was made, and they're trying to hash out exactly what they're going to do about this. And it's not going to add anything to your study, but it is quite interesting to read. We've got ex gratia payment, as we went over before, and then the conclusion is you just tell your client to file a complaint. I've got here the process set out in a bit more detail, and the slides will be uploaded on the Facebook group, I'm pretty sure, so no need to copy all this down. That's just the process. Again, process. And yeah, if no one has any questions, I always get people asking me questions after the workshop, or sending me messages on Facebook or something like that. But if you have questions, really now's the chance to ask them so everyone can benefit, and we can try and work out some answers. No questions? Okay, great.